One employer mistake is responsible for more green card denials than almost anything else in this entire process, and most employees have no idea their case is even at risk until the denial letter shows up. If you're waiting on employer sponsorship right now, or you're an employer trying to sponsor someone, stay with me because I'm about to walk through the exact red flags that get these cases denied, and the very first one alone accounts for a huge chunk of failures nobody warns you about. Let's start with the biggest one, the one that catches the most people off guard: the employer's ability to actually pay the offered wage. Here's how this works. Immigration officers don't just take the job offer at face value. They pull the company's financial documents, tax returns, revenue statements, sometimes bank records, and they check whether the business can genuinely afford your salary on top of its existing expenses. If a company's annual revenue looks too small to cover that salary and keep the business running, the case gets denied. Full stop. Doesn't matter how qualified you are. Doesn't matter how strong your resume is. If the money math doesn't work on paper, the case dies right there. But here's where it gets even more interesting, because that's not even the most common reason cases get flagged. Stick with me, because the next one trips up companies who think they're doing everything right. The Department of Labor audits roughly 30% of PERM labor certification cases. That's the recruitment step most employment-based green cards go through before they even reach USCIS. And here's the thing about an audit. It's not an automatic denial, it's a request for more proof. But if your employer can't produce that proof fast, the case is in serious trouble. So, what actually triggers an audit? A few very specific things. Job requirements that look suspiciously tailored to match one specific person's resume. That's a massive red flag to the Department of Labor, because the entire point of PERM is proving that no qualified American worker was available for the role. If the job posting reads like it was written around your exact background, degree, and work history, officers notice. Wages that fall below what's called the prevailing wage level are another huge trigger. Every job has a government-set minimum wage benchmark for that role and location, and if the offered salary sits below it, or the employer used an outdated wage determination, that case is getting a second look immediately. Here's one almost nobody talks about, and it might be the sneakiest one on this entire list. If the company has done layoffs in related roles within 6 months before filing, that alone can trigger extra scrutiny and additional recruitment obligations. Think about why that makes sense. If a company just laid off American workers doing similar work and is now trying to sponsor a foreign worker for a similar role, that's exactly the pattern regulators are watching for. Quick pause. If this kind of detail is actually useful to you or someone you know going through this process right now, hit subscribe, because we're going deeper into these employer-side traps in upcoming videos. Now, here's a mistake that feels harmless but genuinely isn't. Recruitment that's too narrow. The job ad has to actually reach real American job seekers, real publications, real platforms people search. If a company only posts internally or picks some obscure outlet nobody actually reads, that recruitment step can get thrown out entirely. And if it gets thrown out, the whole PERM case has to restart from scratch. Timing matters here too. The recruitment window is tight. PERM has to be filed between 30 and 180 days after the last recruitment step. Miss that window, even by a little, and the entire recruitment effort becomes void. Start over. Months lost. And here's one that surprises a lot of people because it feels like a technicality, but it absolutely isn't. The employee has to meet every single job requirement on the exact date the PERM application is filed with the Department of Labor, not later, not by the time the green card is actually approved. If someone's still finishing a certification or hasn't quite hit the required years of experience the day that paperwork gets filed, that's a real problem, even if they meet every requirement 2 months later. So here's the real takeaway if you're in this process right now, on either side of it. If you're the employee, ask your employer directly whether they've documented every single recruitment step properly, every job posting saved, every resume that came in, every rejection reason recorded. If you're the employer, understand that an audit isn't the end of the world, but weak documentation absolutely can be. The companies that get through this cleanly aren't the ones with perfect luck. They're the ones treating every single step like it's going to be checked, because eventually, it usually is. Go back to that ability to pay red flag we started with. It's still the one worth remembering most, because it's the one that ends a case before the paperwork even gets to the recruitment stage, before an audit, before a wage review, before any of it. If there's one thing to check first, it's that. This video reflects general information about the employer sponsorship and PERM process. It's not personal legal advice, and every case depends on individual facts. If you're navigating this process yourself, speak with a licensed immigration attorney who can review your specific situation. Before you go, hit subscribe if you want the rest of this series, because we're breaking down every stage of employer-sponsored green cards, one red flag at a time, so you actually know what's happening in your own case instead of finding out the hard way. Thanks for watching.